Hello students, welcome to TSAT classes. Welcome to the classes on Tspsc Group 1 Mains. Welcome to the Indian Polity and Constitution classes. As part of Tspsc Group 1 Mains series, in the last class, we have completed Chapter 1 of Polity, Paper 3 of Group 1 Tspsc. Today, in this class, let us start Chapter 2. Let us start Chapter 2 of Paper 3, Polity paper. So, what are the topics which are covered in Chapter 2? If you look at the syllabus carefully, the first thing is fundamental rights, the nature and scope. Very important is the expanding horizons of the fundamental right. You need to focus on the recent changes or developments within the fundamental rights. Like recently we have economically weaker section reservations, or Maratha judgment, or maybe Shabarimala case or triple talaq case. These are the things we need to focus on, the fundamental rights, expanding horizon. Like recently Supreme Court has said that prostitution is part of right to livelihood as part of Article 21 of the Constitution. So these are the things we need to focus on. Enforceability against the state and others, right? Welfare state, distributive justice, directive principles of state policy, rule of law and fundamental rights. So these are the things we will focus for this particular chapter, that is Chapter 2 of Paper 3. Now let us see the first question. If you look at question number 1, it says, briefly discuss the evolution of reservations since 1950 in India. Discuss the timeline along with legal provisions and judicial judgments. See, this is a very challenging question. You know why this is a challenging question? You need to discuss the timeline of the reservations in India along with the legal provisions in 12 minutes of time. Challenge number 1. The challenge number 2 is, you need to write this within 150 to 180 words. Very difficult. But let us make this easy. Now, whenever we have this type of questions, you need to start with something called the reservations. In the introduction, you need to discuss about the concept of reservations. Reservations is a affirmative action which is linked to positive discrimination principle discussed in Article 14 of the Indian Constitution. Article 14 of the Indian Constitution, which discuss about equal protection of laws, talks about the positive discrimination principle. This positive discrimination is nothing but the affirmative action on certain classes by the state. The main objective of the reservation is to increase the livelihood of socially and educationally backward classes. So this is the introduction. Now he is asking the timeline of the introduction. So as this is a 10 marker, 12 minutes and 150 words, you need to just write down the timeline. Look at this. Put 1950. What are the constitutional provisions linked to reservations? The first one is Article 14. Article 15, Article 16. These are the three direct constitutional provisions linked to reservations in India. Then later we need to discuss about some more articles within the constitution only, and that is your Article 340 of the constitution and also Article 46 of the constitution. Now what is Article 14? Right to equality, equality before law and equal protection of laws. What is Article 15? The state shall not discriminate any person or any citizen. The state shall not discriminate any citizen only on the basis of religion, race, caste, sex, place of birth in providing admissions into educational institutions, including private education institutions except minority educational institutions. What is Article 16? The state shall not discriminate any citizen on the basis of, only on the basis of religion, race, caste, sex and descent in providing employment opportunities, in providing public employment opportunities. Article 340. The President of India can time to time form a committee to look into the status of backward classes in India, to review the status of the backward classes. President can time to time form a commission or committee. Article 46, DPSP, it is a duty of the state to protect the economic, educational interest of SCs, STs and BCs. Okay. So, in 1951, with the help of the first Amendment Act, Article 15 Clause 4 was added, whereby giving reservations to SCs and STs. So, following Article 340 of the Constitution, in the year 1953, first backward class commission, 𝗂𝗽𝗱𝗁𝗃 commission, 𝗂𝗃𝗃 commission was appointed. 𝗂𝗃𝗃 commission was appointed to review the backward classes status in India. I am not going into details. We should not go also, because this is a just 10 marker question. Then in 1963, Balaji versus State of Mysore case. Supreme Court said reservations cannot go beyond 50%. 50% cap on the reservation was bought by Balaji versus State of Mysore case in the year 1963. In the year 1979, BP Mandal Commission, the second backward commission was formed. This is the first backward commission. This is the second backward commission was formed. In the year 1989, an office of memorandum was issued to provide OBC reservations in India as well as economically weaker section reservations. This was again bought by P.V. Narasimha Rao government in 1991, and this was challenged in a famous case called in 1992 Indira Savani case, where Supreme Court gave clarity over the reservations in India. Then we had in 1995 or 1993, 1995 only. In 1995, we had this reservations in promotions was encouraged. Promotions was encouraged. Reservations in promotions was encouraged. Then this was challenged in 2006. 2006 Nagaraju versus Union of India case. And before Nagaraju versus Union of India case, in 2005, 93rd Constitutional Amendment Act inserted Article 15 Clause 5 to bring OBC reservations in India, other backward class reservations in India. Then later on we have in 2018, right, we have Jarnail Singh case on reservations. In 2019, two things happened. Two things. One, 103rd Constitutional Amendment Act has brought economically weaker section reservations. And second thing is, in 2019, Maratha judgment on reservation took place. In 2022, Supreme Court upheld the economically weaker section reservations in the country, taking the reservations to 60%. Taking the reservations to 60%. See, if you go into the details of the answer, you cannot finish in time and it is very difficult to justify your answer. You have to write a timeline in this way so that you will finish the answer and also make sure that you will get maximum marks. So this is the timeline you need to focus for this particular question. What is that question? Explain the timeline along with the legal provisions and judicial judgment. See, we have included the legal provisions and also judicial judgments like Indira Savani, we have Balaji versus State of Mysore, we have Nagaraju versus Union of India, Jarnail Singh case, Supreme Court case in 2022, that is on economically weaker sections. This is what you need to focus on for this particular question. Let's continue to the next question. Yes. Highlighting the significance of the fundamental duties in India, examine the existence of legal provisions for their implementations as recommended by Verma Committee. Highlighting the significance of the fundamental duties. You have to highlight the significance of the fundamental duties and examine the existing legal provisions as recommended by Verma Committee. Very important question. Now in the introduction you need to discuss about the fundamental duties. Fundamental duties. Fundamental duties are discussed in part 4 of the Constitution, part 4A of the Constitution, discussed in article 51 capital A. Discussed in article 51 capital A. Fundamental duties are added in the Constitution by 42nd Constitutional Amendment Act 1976. They are added by 42nd Constitutional Amendment Act 1976. And they are recommended by 𝗧𝗦𝗔𝗧 Singh Committee. They are recommended by 𝗧𝗦𝗔𝗧 Singh Committee. When these fundamental duties were added in the Constitution, there were 10 fundamental duties. There were 10 fundamental duties in 1976. And presently there are 11 fundamental duties. Presently there are 11 fundamental duties. The 11th fundamental duty is added by 86th Constitutional Amendment Act 2002. The 11th fundamental duty is added by 86th Constitutional Amendment Act 2002. Now what are these fundamental duties? Fundamental duties are the duties to be performed by citizens only. To be performed by citizens only. But the question is, are they enforceable? If a citizen is not performing the duty, can we take that citizen to the court? Are they enforceable like fundamental rights? Absolutely not. Fundamental duties are not enforceable in courts. Fundamental duties are not enforceable in the courts, and this is the question mark. If they are not enforceable in the courts, what is the need for fundamental duties is a question mark. So the reason in 1999 Verma Committee was formed to provide recommendations on making the fundamental duties enforceable. Now what Verma Committee said? Verma Committee said, although Constitution of India did not made fundamental duties enforceable, there are already certain legal laws in India. There are already certain secondary laws in India which make the fundamental duties enforceable. Which make the fundamental duties enforceable. Now what are these legal provisions is what the question is all about. Now what are the legal provisions? Let us see what are the legal provisions which make the fundamental duties enforceable. See, one of the fundamental duty is to respect national anthem, national flag, and abide or follow the Constitution of India. And follow the Constitution of India. If any citizen is not respecting the national flag or national anthem or not following the Constitution of India, he will be charged under National Honor Act of 1971. 2. A citizen cannot go against the security of the country, the sovereignty of the country. If any person is going against the security of the country, he will be charged under IPC, Indian Penal Code, CRPC, Criminal Procedure Code, CPC, Civil Procedure Code, or his organization or himself can be banned under unlawful activities Prevention Act. Unlawful Activities Prevention Act of 1967. One of the fundamental duty is to respect the dignity of women. If any person is not respecting the dignity of women, he can be booked under Domestic Violence Act 2005 or Indian Penal Code 1860 or 𝗧𝗧𝗧 Act. So there are certain legal provisions I'll tell you one more. If one of the fundamental duty is to respect and have compassion towards living creatures and protect the environment. If any citizen is not having compassion against the living creatures and not protecting the environment, he can be booked under Environment Protection Act of 1986. So there are certain secondary laws in India which indirectly make the fundamental duties enforceable, is what said by Verma Committee of 1999. Let us go to the next question. Freedom of expression, speech and expression, freedom of speech and expression enriched under Article 19 Clause 1 of the Constitution is not absolute. It comes with reasonable restrictions outlined under Article 19 Clause 2. What are these reasonable restrictions and the need and significance? See, firstly, Article 19 is very important fundamental right. Article 19 of the original Constitution discussed about 7 freedoms for the people or citizens. But presently, we have 6 freedoms within Article 19. If you look at Article 19 Clause 1 Subclause A, Article 19 Clause 1 Subclause A. Why did I take Subclause A? Because it is mentioning about 19 Clause 2. The reasonable restrictions for 19 Clause 1 Subclause A is mentioned in Article 19 Clause 2. Right? These are the freedoms and this is the reasonable restriction. So we need to take this line to line. Now what is Article 19 Clause 1 Subclause A? Article 19 Clause 1 Subclause A talks about freedom of speech and expression. Now you have all the freedom of speech and expression. You have all the freedom to express yourself. How to express? Article 19 Clause 1 Subclause A says, your freedom of expression can be given by a speech, by writing a book, by posting something in social media, by singing a song, right? By writing an article, also by remaining silent. Right to remain silent is part of Article 19 Clause 1 Subclause A, as said by Supreme Court in 𝗳𝗍𝗻𝗄𝗎 versus State of Kerala case. Not only that, right to internet access is also part of Article 19 Clause 1 Subclause A, as said by the Supreme Court in Anuradha Basin versus Union of India case. So you have all the right to speech and expression in these many forms. But our question is, are these rights absolute? Right to speech via book, via media, broadcast, social media, song, or you draw something, or you write an article in the newspaper, or right to access to internet, or right to remain silent. This freedom of right to expression, which is guaranteed by the Constitution under Article 19 Clause 1 Subclause A, is it absolute or not? Is a question mark. It is not absolute because this freedom of speech and expression comes with certain restrictions. The state can impose certain restrictions to stop your freedom of speech and expression. Now what are these restrictions? Discussed in Article 19 Clause 2 of the Constitution. 19 Clause 2 of the Constitution talks about reasonable restrictions for your 19(1)(a) freedom. Now, what are these reasonable restrictions? 1. If your speech, if your freedom of speech is going against the security, integrity, sovereignty, law and order of the country, if whatever you speak is threat to the India, it is creating a law and order problem, then you can be arrested. The state can take action against you. 2. If whatever you speak or whatever you express is providing or is ensuring defamation, that is defaming someone, the state can take action against you. 3. Contempt of court. Now, if your speech, if your expression is going against the court's order, or you are going completely against the court, judiciary, then the state can take action. 4. Incitement to a crime. See, what is the meaning of incitement? Provoking someone to a crime. You are provoking something which is leading to a crime, then your speech and expression can be stopped. 5. Not only that, if your speech and expression is hurtful to, friendly relation between India and other countries, if it is going against the friendly relation between India and other countries, the state can take action against you. Meaning, the right guaranteed to you under Article 19, Clause 1, Subclause A is not absolute, because state can impose restrictions by following these things which are mentioned in 19 Clause 2. If you look at the first point, security, integrity, sovereignty and law and order, the state can take an action against you by imposing sedition charges. Under Section 124 Clause A of Indian Penal Code. Sedition, going against the country. So, the state can take action. All fundamental rights are guaranteed, but not all fundamental rights are absolute. Many fundamental rights are not absolute because they can be restricted by the state, and this is called reasonable restriction. Sir, who gives this reasonable restriction? No one gives. It is mentioned within the Constitution only. So, this is the answer for this question. Look at the next question. Elaborate the nature of the directive principles of state policy. Discuss various amendments to Part 4 of the Constitution. Elaborate the nature of the DPSP. Directive principles of state policy is discussed in Part 4 of the Constitution from Article 36 to 51, inspired from Irish Constitution. DPSP is nothing but certain philosophical principles to be followed by the state. DPSP are not directly enforceable. There should be a law or policy to enforce DPSP. DPSP, the main objective of DPSP is to bring social and economic justice DPSP talks about three types of philosophies. One is called Gandhian philosophy, socialistic philosophy, and thirdly liberal philosophy. Now the question, this is your introduction part. What is the question? Discuss various amendments to the DPSP. Now there are three important amendments to DPSP. Let us discuss all these three along with one more, which is minorly important. The first one is 42nd Constitution Amendment Act 1976. The 42nd Constitution Amendment Act added 5 directive principles of state policy. That is your Article 39 small e, Article 39 small f, Article 39 capital A, Article 43 capital A and Article 48 capital A. These are the 5 important directive principles of state policy added by 44th Amendment Act of 1976. The second one is 44th Constitution Amendment Act 1978. 44th Constitution Amendment Act added Article 38 Clause 2 of the Constitution. Okay. The next important amendment is 97th Constitution Amendment Act 2011. 97th Constitution Amendment Act 2011 added Article 43 capital B. See, 43 capital A is added by 42nd and 43B cooperative societies, 97th Constitution Amendment Act, and lastly the 86th Constitution Amendment Act 2002. This modified, see, did not add, modified Article 45 of the Constitution. This modified Article 45 of the Constitution is related to education. So this is a model answer for this particular question. So we will continue the chapter 2 again in the next class. Till then, please try to write the answers, gain knowledge. So revise once again. So I'll see you in the next class with part 2 of chapter 2, TSPSC Group 1 Mains. Till then, happy learning. Jai Hind.